today. And I think you should have your slide up there, maybe this video feed, so you can see what color my tie is. This is designed to be a very basic introduction to Medicaid program, and specifically for the elder law section, paying for long-term care, which is what my office does quite a bit of. Just by way of background, in terms of my work, I graduated from St. Thomas up in Minnesota. There's actually an elder law clinic there, and so I took that my last semester of law school, and also ended up getting hired to teach, which was a great experience. And I got to teach, supervise students, and handle a lot of people at that phase of my career who did not have a lot of resources, many of them whom had been on Medicaid for some time. But because of some of the pitfalls, some of the complications surrounding Medicaid eligibility, specifically Medicaid eligibility for long-term care, a lot of them would lose their eligibility, and people would bounce on and off the program, and sometimes arguably through no fault of their own, lack of sophistication and understanding of the program. Certainly don't want that happening to your clients. But at this phase of my career, I do a lot more proactive planning. Certainly do a lot of crisis or at-need planning for Medicaid. But we take everybody from folks who may need to apply in the near future to pre-planning, 5-year planning with the look-back period at our current work. So I practice in both Nebraska and Iowa. Grew up in Iowa and Carroll. My dad Joe's an attorney back there, and a member of the National Academy of Elder Law Attorneys, NALA, a nonprofit group, does some lobbying, some advocacy, a lot of education in this area. I'm an accredited veterans planner, the VA accredited attorney, so I can submit VA applications on folks' behalf, and then if you do an appeal of a denial, you can get fees. If you do any VA work, you have to be careful about when and what you take fees for, because they have some very strict rules about that. But look, that looks like we're right about at capacity, so welcome everybody. For those of you who just were the last couple chimes joining the group, this is designed to be a very basic Medicaid introduction to get your feet wet, and hopefully point out the major issues. Hopefully everybody got the basics of Medicaid webinar materials that, let's see if I can do this, that they should look about like that. Yeah. So those are the materials, and I may or may not scroll through some of this. We've got a lot of quotes from the main source that the department uses here, their state manual, and there we go. We'll get the slide back up, maybe, and we'll just kind of go into it here. So on the big level, because this is a basics webinar, so who started all this trouble? Well, Medicaid is designed to be the health insurance of last resort. Courts love to recite that line. If you read any appellate or upper level cases on Medicaid, they're always talking about this as the insurance of last resort, and that's more than just rhetoric. That Medicaid actually written into the law is that whatever other essentially coverage a person has is always accessed before Medicaid. So you can't get an insurance policy that kicks in after Medicaid. It's the last resort. It's the last payer. If you have any other coverage, you have to access that first before you access any Medicaid benefits. And the state starts paying. It's established at the federal level, Title 19 of the Social Security Act, and of course it was elective that states can participate. Of course they are all 50 states participating at this point. the pervasiveness of this program was actually significant in the Supreme Court decision on Obamacare, on the expansion of Medicaid, basically saying that it is no longer a viable option, was part of the court's analysis. It is no longer a viable option for states to opt out of Medicaid, and so the expansion of Medicaid became voluntary on the part of the states as part of the Supreme Court case involving the major challenges to Obamacare. Here we go. There are of course, as the insurance of last resort, significant income and asset limitations on when people can access Medicaid. The rules are often considered a bit unduly complex for need-based individuals. As I was referring to before, I started my career in the nonprofit sector. Had a lot of people getting kicked off Medicaid who were, by any definition, by any person's definition, certainly financially needy. You know, whether you have a white-collar background with you know, savings, and your nursing home care depletes your savings, you want to save something for your spouse, or whether you've been on Medicaid for years and years, you can end up getting kicked off. There's a lot of little tricks or traps here in this system, I would say, that can get you. We'll try to highlight a few of those here as we go over the big picture again of eligibility and what people need to have. The benefit here for nursing home residents or long-term care, people receiving long-term care, and that could be in an assisted living facility, that could be receiving services from an in-home medical agency, either in your apartment or even in a senior living apartment. Those are all potentially, again, funded by Medicaid if you meet the appropriate requirements. The benefit's significant. You're paying basically your income towards your care, and the rest of your bill is covered. It's obviously different benefit for each individual. If you've got a good significant income of $3,000 or $4,000, which I do see once in a while, and your nursing home bill's $5,000, well, you're getting $1,000 a month that Medicaid is covering and saving for you effectively. But you also get a lot of people with maybe less than $1,000 of Social Security income, but a nursing home bill of $10,000 or more a month, and Medicaid's covering essentially all the rest of that, saving that for your client. You know, of course, the Medicaid system isn't paying those private pay rates. What insurance does, after all, pay the same rate as privately paying individuals for medical care. They're getting a reduced rate and paying out less than your client would be. But when you talk to them, or you walk them through the benefits or the potential upside of Medicaid eligibility and Medicaid planning, you know, highlight that, you know, effectively you're out X number of dollars every month, and we're going to limit that through a Medicaid application, Medicaid eligibility, to just a portion of your income, most of your income in most cases, but a portion of your income as it comes in each month. And that's the part that really frustrates a lot of clients, is that they're dipping into their savings, significant dip into savings every month, that you know, most people didn't want saving that to pay for a nursing home. They don't want to be there. It's frustrating that they're paying it and that it's so very expensive. You know, as an initial warning, you have to be very careful, you know, especially if you are new and you're taking this introductory basics course for that reason. Clients will come in with misconceptions. That's not at all surprising to me anymore. You know, they may hear from a facility that, you know, well, you just got to get that application in, you know, if you get it in this month, then they'll go back the last 3 months. Well, that may be true. It's possible, under the limited circumstances that the person is in a skilled nursing facility. If they're at home or in assisted living, that rule does not apply, and there won't be coverage for those months. And you have to prove eligibility not just for the month when you're applying, but for all those other months. And if they're $1 over their asset limit, then they're not eligible. It's a hard line. The $4,000 is not, a ballpark number. It's you just got to meet it. There's got to be a cutoff. And if your balances didn't line up or what have you, you won't have eligibility. And so obviously as a practitioner, you don't want to rely on that, any more than you need to. Certainly not if you're the one submitting the application. Don't give yourself 3 months to get it. And obviously the other downside practically to that is the facility is not getting paid for an extended time. Who likes to get paid 4 or 5, 6 months late? I don't. All right. So on the income side, which is usually the simpler one, especially here in Nebraska, we have what's called the medically needy standard for income, where we take your income, we subtract your medical care to reduce it, and that's your effective income for the program. So most folks in long-term care have an effective income of 0, which certainly meets the standard. If you do have higher income, you do have to watch that. You have to, be very specific about the costs that the individual has, and then the amount of income that they have, and the amount of medical costs that they have. They're for relatively high income individuals. One thing to remember is it is just the income of the individual applying. So if it's Mr. and Mrs., whoever's not applying, whoever is what we call the community spouse, the one who's still presumably living in the community, not receiving care, not applying for benefits, that person's income is actually not part of that equation. It's factored in later. Actually, we can get that person some income, which really, really helps, especially if you had the most common place where we see that is the wife who's still at home, didn't work perhaps, and so does not have significant Social Security income or other pensions. But the income eligibility to get the client on is you're going to be looking at just the income of the individual who's applying for benefits. You're going to subtract the care and see if you meet the standards. Typically, it's going to be 0, so I'm not going to discuss that much more. But and if it gets higher, you're really going to have to delve into, just where you can find deductions. Also, we've had people increase their medical expenses by buying a dental policy, buying a Medicare supplement, buying sort of a gold or platinum type plan, of insurance, and that can. Often if it's very few people are far over income. Most people, if there's an income issue, are pretty close. And in terms of planning and getting Medicaid to cover the care, again, it's not going to be a huge contribution, frankly, if they're that close, and then Medicaid's paying a lower rate. But that may be something that you want to do, establish it, especially if increased care needs are anticipated in the future, so that as care needs increase, it's not additional expense to the client that would be on Medicaid. So, and then once the client's on, they've met that, on the income side, they've met that qualification. You can tell clients there's not going to be much flexibility in what you can do with your income, and generally, if you're trying to do any sort of asset preservation, help out the spouse, typically make sure they get everything they're entitled to. It's very difficult, and really usually you're just not preserving their income. They do get a personal needs allowance, $60, I believe, each month, and then they can, as I alluded to before, give some supplemental income to a community spouse. We talk about the monthly minimum needs allowance, the OMAHA, if you like acronyms for that. It's anywhere from about, the upper level of sort of $2,000 a month. It's one of the various numbers here, sometimes referred to as the magic numbers, that change every year. Some of them change at the beginning of the year. Some of them change at the center of the year, in the summer. And so you need, there are good, reliable sources out there for those numbers. I don't know if I included a link in my materials, but Kraus Financial does some, out of Wisconsin, does a lot of financial products that are geared towards this planning, and they have some useful links. As one example, KRAUSE up in Wisconsin. We work with them sometimes, so they're a possible vendor. So the personal needs allowance is what you can tell the client they're going to be getting as sort of cash on hand. If they don't spend that, it goes towards the assets. It can creep up over time. You don't want to allow them to do that. Find a way to spend your $60, and even spend more than that. Because I really, once folks are on the program, there's no reason to be anywhere close to that $4,000 mark. You get them down there to apply and get on established eligibility, and then, buy them something, get the assets down even further, in my mind, because rocking on and off of the program is not going to do any good to anybody, and really be frustrating. We try to enter them in at least a few $100s below the $4,000 when we apply, if we can, in my office, and then encourage them to, go out to eat, go to nice places, tip well. If you can still get out and go to movies, etc., that's fine. If you can get a subscription you can pay for a nice cable subscription or HBO or whatever, do those kind of things and whittle that $4,000 down even further. Anyway, I list past medical bills here. There is a provision in the Medicaid law that if a person, comes to you, you're usually not doing asset preservation here, but, sometimes because of past medical debt, even debt to the facility that they're at, because the application, maybe a prior application was botched and didn't result in eligibility and any coverage, you've got a back bill. There is a provision that I refer to as the unreimbursed medical expenses provision under the budgeting for Medicaid, where their income should be able to go towards any past due medical expenses. I know that there's actually a questionnaire that they send out to providers that I've seen in Iowa, where they ask them if there are any of those, and then the Iowa Medicaid system actually factors that into the budget, which is great to see. Other states are not so excited about this. I was at the University of Minnesota. They didn't like the rule very much. It's, as many Medicaid rules are, a little counterintuitive, that there would be past bills that you would allow the person to still pay while they're on Medicaid, but that is the law. And sorry for that ping. I don't know if I can shut that off, but it won't be a problem. The state of Minnesota didn't like the rule very much, but clearly we were able to establish that in Minnesota. I've wrestled a few times with the state of Nebraska on it. If it's very important to a client, you can contact me about that. I can walk you through what needs to be done to pay off past medical bills, especially ones at the facility they're at, because if you've got that unpaid bill sitting on your client's ledger, then they're always potentially in a position where they can be discharged, and so it really increases the stability of their situation if we are if we don't have any debt to the facility where we're staying. And then there's a grab bag at the end, contribution to care. When you get your notice of action, it's actually called share of cost in Nebraska. So you'll get a notice of action from the department. It'll say Medicaid is open as of the first of some month, and your share of cost is X. Okay, if you had any sort of penalty, any sort of gifting penalty, the share of cost will be a lot bigger that first month if there's a partial month of penalty, and then it'll go on to their standard one. And of course, it changes whenever income changes. You have to report changes in income when you're on the program, and they will adjust essentially your share of cost, often just dollar for dollar. So the increase in income for clients, after they're on the program, just affects the amount of the check that they have to write to the facility. It's not not something that really changes their situation very much, unless they have a community spouse, and that community spouse is not able to get up to that minimum monthly needs allowance. Then when the increase in income comes, they can give even more to their spouse and get them closer to that maximum monthly maintenance needs allowance that we, really helps a lot of the, especially typically it's been women, of course, but any person who, for whatever reason, doesn't have significant income, the spouse doesn't have significant income of their own. All right, so Medicaid and assets. This is where most of the action is. Most of the planning goes on here, and most of the difficult, I guess, planning questions come in because people own a lot of different stuff, and sometimes some of them can be very difficult to deal with. So this is sort of the meat of the presentation here, and what we want to talk about. I always break down assets into three main areas. They can be exempt, so there's exemptions for certain assets. You'll always hear that the house is exempt. Well, make sure that somebody's living there and that they meet the right criteria. Now, there's obviously, if your client, who's the applicant client, is living there, that's fine. They can live there, it's exempt, and they can be receiving elderly waiver, is what you call it when they're in the home, elderly waiver version of Medicaid benefits to help pay for folks to come into the home, long-term care, in-home services. If they're in a facility and their spouse is still living at home, that gets it an exemption. There's also, I believe, if you have a minor or disabled child, and possibly if they had lived with a sibling, which does come up from time to time, there's a sibling who's a co-owner, you also have an opportunity to keep the house, exempt or away from, use the house, don't let the house prevent them from eligibility. But for the single person, unmarried person who goes into the facility, owns the house, that house is not exempt, or at least it won't be for long. There is, if you really want to argue about that a little bit, there are rules about the intent to return to the home, and that's a difficult fight, and it needs to, usually most states the ruling is it has to be a reasonable expectation that they return home with folks in long-term care. That can be a hard case to make, but if that's what is important to your client, you can try to extend the exemption even without someone living there under that theory. So the house is exempt, possibly. One car, so that's always the most valuable one, of course. Make sure you list it that way on your application, all your materials. Make sure that you exempt the most valuable of the vehicles. And personal property generally is not analyzed. I haven't really had many cases where there were, very, very valuable collections or art or any of those types of things. And I guess those are technically items of durable, material, personal property. But then they're not going to go through the client's house typically and look for stuff. It's all going to be on paper, the electronic online application, and then whatever you fax or submit in online in terms of documentation. There's a dot there on the slide for unavailable assets. So the general rule being, if you can cash it out, if you can get money from it, if it has value, you go do that, sell it, spend it down, come back, and then we'll start paying for your care. Okay? If it's really tied up and the client cannot sell it on their own and can't force a sale, then it can be treated as unavailable. The most typical things that I've seen that meet this criteria are real estate that's titled jointly, perhaps. Maybe the client was given a life estate or did a life estate deed. We'll talk about gifting and how the life estate came about later. But if it's wrapped up, if there's another co-owner and the co-owner makes a statement that they're not willing to sell, then then you can get the property treated as unavailable for the purposes of the program and just not count it. So if you fit into the exempt or unavailable categories, then it just counts as zero and not at all towards the applicant or possibly their spouse's asset limits. And we'll talk about the spousal impoverishment rules in just a moment. So, and then everything else is countable, okay? If you can't get it exempt, you can't get it to be unavailable, then they're going to count it. As an asset, you're going to have to come up with a value, established value. Assessed values are routinely accepted. If that's way too high, just like I guess for your inheritance tax proceedings or anything else that you would do, I assume a lot of the folks on this call are doing those kinds of things. If you're interested in possibly doing some of this work, get a real assessor, get a real assessment done, and get a market value, and get those values established. Lower if you can. Everything else is countable, and exemptions for tax purposes or exemptions from asset protection from collection. None of those are going to apply. A lot of rules that you learn in other areas of law are just not going to translate into Medicaid. That was actually, I didn't say that in my materials. One of my general principles for learning Medicaid there on the first page is forget every other law that you know, or at least don't assume that they apply. Certainly the gifting rule, the $14,000 annual exclusion for gift tax filing, that has no bearing on Medicaid, I think with the shift in the rules on the estate recovery, we're getting even further afield, possibly, from the way that the laws apply in other areas. Doesn't mean that it's not worth arguing that other laws, contracts, real estate ought to be followed, and I've had some success with that sometimes. But there is, there are ways in which Medicaid gets to treat things very differently than anybody else does. Anyway, so if it's not exempt or unavailable, it's countable. Watch out for things that may lose their exemption or become available and therefore countable. Also, obviously, an exempt property with the spouse living there, you should actually deed the property into the spouse's name. Practice tip there. The community spouse should always be the only person on title. If they have to, especially because if they have to move away, and the other spouse is still on title, lost your exemption, and is potentially disqualifying. And also, if you do a sale, they're the only one on title. They can keep the proceeds, right? Because they're the only person on title, and you've, of course, as a good Medicaid planning elder law attorney, you've gotten the community spouse is the only one on title. So, and obviously things that were unavailable could become available. If there's joint tenancy property, the other joint tenant passes away, then, then your client's the full owner again. And so it could become available. and it could be subject to liquidation, therefore an asset to the client. So if the joint tenant outlives your client, then they should receive full ownership, just like regular real estate law would dictate. There is, of course, some legislation pending that would try to prevent that and change that part of real estate law in the Medicaid asset recovery context. So now talking specifically within the discussion of assets about the community spouse, that person is married to the applicant, is living in the community, can be a house, apartment, but not in the same unit as the spouse. If they move to the assisted living with them, the state of Nebraska will not treat them as a community spouse. That's a very hard thing to. I don't think it's very sensible. I just disagree with the rule. But if they both are living in the facility, assisted living, you may lose this protection, or at least that's the state of Nebraska's position. The exact amount is called the Community Spouse Resource Allowance, okay? We look at their snapshot date, as I refer to it with clients, the date when they moved to long-term care or were first in need of long-term care, which is sometimes, if they were in the house and they started receiving services, it could be the time you started hiring those folks, which is problematic. Because they don't have any stay outside of the house. It's very challenging. The state makes it very challenging to get in-home services paid for by this program. But first, the simple example: the person goes into a hospital. They're there for at least 3 days, right? So that you can trigger your Medicare, not the subject of today's seminar. Your Medicare coverage for up to 100 days of rehabilitative services, sometimes in a facility like this, in what is otherwise a long-term care facility. But Medicare is not paying for long-term care. There is no long-term care properly benefit under Medicare. They are paying for the rehab and the rehab stay. Once they become a long-term care patient, they're not receiving rehab anymore, or they just get to the end of that 100 days of rehab benefit, they're in long-term care. In that case, you could have that 100 days, you could have the stay in the hospital. The snapshot date is still when they left the home, okay? So when they go to the hospital, that's your snapshot date, and that's the time that the client has to submit and document, what were my assets at that point, okay? And that's your IM-73 that's referred to in your materials. That's the name of the form. So you have to, if you're going to do a spousal case and there's a delay between when they went in and when they are applying, all right, you're going to have to actually prove the status of the assets at 2 different dates, okay? And so, in my intake materials for our firm, we actually have all the assets listed twice, then and now. When your loved one first went into the facility, which could have been 2 weeks ago, 3 months ago, could be 2 or 3 years, and people privately pay for a couple of years before they come and see an attorney and evaluate the potential to get coverage. So, for some people that's actually kind of a challenge to get that data together, but that's the data you need, and you want those numbers to be high. Okay, you want those numbers to be high, because the spouse will be able to keep anywhere from a minimum of $23,844 this year. That's another annually increasing number, to a maximum of $119,220. So there's a big gap. 5, almost 6 times difference in what the community spouse can keep in the bank in countable assets. This, again, this distinction between countable, unavailable, and exempt carries through for the analysis of the assets of both spouses, and there's a real big range there. So You get to that number by just taking that snapshot date and dividing that total assets, countable assets, by 2. And if you get in the range, right, somewhere between 23,000 and 119,000, then that's what they keep. Their community spouse resource allowance is set at that amount. If you divide by 2 and it's only 20,000, well, they get the minimum. If they had 300,000, divide that by 2, you get 150. You don't get 150. You get 119 and change. And so what you'll have to prove in order to start eligibility and coverage is that you have the community spouse resource allowance, whatever it is. Hopefully for your client it's 119,000, plus the 4 that the recipient applicant spouse can keep, and that's their individual asset limit is 4,000. If you're over in Iowa, it's 2,000, and I don't know the other states. Minnesota, it was 3 when I was up there. But that number for the applicant spouse actually varies state to state. But we're just going to focus on the Nebraska here because it's a Nebraska State Bar Association presentation. And thank you to those folks for setting this up and helping me. Hopefully this is going as smoothly as it seems to. Everything seems to be working. I don't see anything on the chatter yet. I don't see any questions. But if you do have questions, pop them in there. And I have been looking to see if anything comes in. Anyway, the asset limit can change. Here in Nebraska, 4,000, relatively high actually, for what that's worth. Still less than it costs for a month of nursing home stay. So it's a somewhat insignificant amount, no matter how low you go at that phase. But you want to be able to prove your client's got the 4,000 plus the CSRA, whatever that is. So it's up to 119 plus 4, 123,220 would be the absolute maximum that could be in either spouse's name and get the applicant spouse onto Medicaid. Okay, and we always shoot to be below that because you don't want an interest payment or something else coming in and bumping you over that amount. This you don't want to have them bumped off. And then the CSRA is actually as opposed to the 4,000, which is going to have to be maintained to maintain eligibility the entire time. Your CSRA is actually kind of a gatekeeper amount, if you think of it that way. You're going to have to prove that they were there to get them on. Then you have your IM-73, okay, that helped you determine what the CSRA was. And then you're going to have to, within, I believe it's 90 days, it's in my material somewhere, within 90 days of that, you're supposed to submit, you're supposed, well, I don't know when the form is due, you get an IM-74 that says how you're going to divide it, okay, between the two spouses. And you have 90 days after they're approved to get that done. All right. We've got a little bitty chat window, but we do have a question. Retirement accounts are available. Thank you, Matt, for your question. There are some states where apparently there's some protection or different treatment for retirement accounts, but pre-tax dollars are not exempted. They are something that the client could cash out and get and pay for their care. And that's how Medicaid looks at it, is you can cash that out, you can get the money and pay for your nursing home, so we're not going to pay for it yet until you do that or do something else legally acceptable with the money. Is my client still going to take a tax hit when that happens? Yes, possibly. There's no exemption for cashing out an IRA because you need to liquidate it and pay for your care necessarily. You do have a lot of deductions though. All this medical care is income tax deductible, and so when we have people cash out IRAs to get on the program, even if we're not using those funds for care and we're trying to preserve them somehow. We very rarely have folks take a big tax hit. Maybe I just haven't come across that case yet. Actually, I had a client recently who paid like a default, suggested tax rate and ended up with a huge refund. More than 15, I think it was like $20,000 that they ended up getting back. Okay. Now we're getting kind of active. Oh boy, what do we got? Oh, did I miss anybody before that? Okay. So Frank has a question. Okay, this is a good question. Frank is asking about the IM73, whether that's related to the 5-year look back that we're getting to in the next 18 minutes. And no, okay, if the snapshot was 7 years ago, it would still be when he went to the hospital and then went into nursing home and whatever. If it was 7 years ago, the snapshot date is there. The snapshot date is when you went into care. It's not limited by the 60 months. You don't necessarily have to report what their assets were 5 years ago. That's not what you're reporting. The IM73, you're reporting what the client had and the spouse had. You're only doing it, I believe you're only doing it when there's a spouse, because otherwise they wouldn't need to determine a community spouse resource allowance. So the IM73 is when they went into care. The 60-month look back is a completely different rule. So don't mix up your your variety of confusing Medicaid rules. The IM73 is not directly related to the gifting rule. Would I recommend annuities over defined contribution retirement accounts because annuities are deemed income rather than assets? Nathan, thank you for the question. If I'm recommending a financial product to somebody who's trying to get on Medicaid, you can't just send them to annuities in general, because the gifting rule actually considers purchases of annuity that are not Medicaid compliant to be a deprivation. So you have to be very careful that you don't have clients trying to create an income stream that is not compliant with the program. You should only be buying an annuity that is really Medicaid compliant, that is probably only marketed for these purposes, because if it fits the Medicaid requirements, then it's an odd duck kind of probably, and you need to and that can be used, and we'll try to touch on that. This isn't only an hour presentation, so we'll try to clip along here. So you can be penalized, as Frank was pointing out, for gifts in the prior 5 years. Now in Medicaid, we're always thinking in months, so it's actually 60 months is how you should probably think of it. So if a deed was recorded within the 60 months before the month of application, then that's in the look back period. Don't count days, don't use the date, use the months. That's actually a good general principle that's in my materials for Medicaid. Is always think in months. You can be penalized for giving things away. The way that they can compute that used to be under the old rules, which ended when I was in law school, but you'll hear people talk about the 3-year look back if whoever they talk to about Medicaid has been out of the loop for 10 years, as long as I've been practicing law, but I've had some in the last couple of years. Used to be, you gave a gift, the penalty started right there, so people would they'd gift a little bit, and the penalty would sort of dissipate, and then they'd wait till all those dissipated before ever applying. That type of planning is no longer makes any sense, because the current rule is you look back over the last 5 years, you add up all of the gifts or transfers for less than fair market value. Okay, so the sweetheart deal where you sold the son the farm for pennies on the dollar, that can be penalized. You know, you add all of those up cumulatively over the last 5 years, and then you divide that by the cost of care at the private pay rate, not at the Medicaid rate, but what your client's actually paying. So that's a thing you got to watch. If their care situation is uncertain, if they haven't been there, if they're not kind of stable in their care situation, and that number might change, you got to think about when is the best time to apply if there's going to be a penalty, because if that number gets bigger, okay, if the number on the bottom of your division gets bigger, then your penalty gets smaller, right? But you're stuck with that penalty. So you take all of the gifts, divide by the cost of care, the cost of care in the month when you're applying, and that's your penalty. Costs go up, costs go down, you're stuck with that penalty. That's the consistent treatment, whether it, and that can benefit your client if costs are going down. That can benefit the state, I guess, if costs go up, and you're having to stretch dollars even further to get through a penalty for your client. So that's part of the risk whenever there's either a plan or you just have a client who comes to you with a history of gifting and you're planning around that. All right, questions. Let's talk about, that's the estate recovery slide at the end, and we'll touch on that. But so generally, talking about Medicaid and gifting, you got to ask, and you got to get the information about any prior gifting the last 5 years. One strategy is, gosh, that was 4.5 years ago. Can we get through the next 6 months without a Medicaid application? We may have to ask, what do we need to do in terms of assets to keep the person, to get them through a penalty period. If you're going to have, you got prior gifting, or you decide to do some gifting and create a penalty period, then you have to cover it. Nathan's question about annuities comes in here because if you buy a properly structured product, a Medicaid compliant annuity, the purchase will not be penalized. The money can come back to your client during the penalty period and pay them through that penalty. Now, and like I said, there's two kinds of those penalties. There's the one that you advise them to do intentionally. If they want to do some limited gifting, they have to do that in conjunction with the annuity to get them through the penalty period. If they've done significant gifting in the last 5 years, you kind of have to act quickly, hopefully, as the money is going fast, and make sure that you can get an annuity in place that will pay for the care during the period of the penalty. The penalty, and one of the big changes from that 3-year model where the penalty would go away with or without an application, one of the big changes was, obviously 5 years is a long time, but also the penalty doesn't start until you've applied and been found eligible. Okay, so you don't start to get through the penalty until you're down to eligibility, which is $4,000 for the applicant. If they've got a spouse, they might have $119,000 or less in the bank at that point. So that's a severe penalty to not have any coverage from the insurer of last resort at that point, and it's frankly meant to be a severe penalty. The mechanism that we've used, I referred to Kraus Financial on their website before, and they sell. They can be a broker for these Medicaid compliant annuities, and we've used them. There are lots of other vendors that we've been using currently. The mechanism there again is to actually use the purchase of the annuity to get the client assets down, because the annuity, as Nathan indicated in his chat, I don't know if you guys see that, but it's income. It's not assets anymore. I always tell the clients, look, you're just as wealthy. It's not a real change in your overall net worth, or maybe a marginal one, but it gets it out of the asset column for Medicaid and puts it into income. And assets are disqualifying you, or disqualifying the client, and you have room to grow in your income, which is usually why they're there in your office, because they don't want to be dipping into savings. They wish their income could cover their care. Well, it's not exactly what they want to hear, but if we just take some of those assets down and we put them over onto your income side of your wealth, then, because of the way that Medicaid treats assets versus income, you've become eligible. And especially if you've got gifting in their past, they almost need to do this to keep the facility paid continuously. If they've got gifts in the last 5 years, it also creates the opportunity, right? Because we know that we can cover a penalty period through the use of a properly structured Medicaid compliant annuity. And so if we want to do gifting, we can work usually in conjunction with the annuity company in terms of what kind of payments they're going to be able to provide at what cost, and potentially give away some funds and cover the resulting penalty. They have to obviously be very careful, double check your numbers, make sure that there's no other assets out there. Had one of those recently where, oh surprise, mom had another couple life insurance policies. Life insurance policies, another good example of something that most people don't look at as an asset. Okay, if you're going to discuss assets with a client, they might not, they may not mention life insurance policies. So we ask them specifically for any annuities, any life insurance policies, and name those types of products because of the odd rules, regarding annuities and the very narrow qualifications that those need to have to be Medicaid compliant. And also because if your life insurance has cash value, that's something that, like I said, the default rule, if you can go cash it out and pay for your care or spend it otherwise legally, the department will tell them, spend it on their care. You as the attorney, of course, just politely correct them and say, of course, you can spend it on yourself, you just can't give it away, and you will not incur a penalty. And of course, if clients want to pay for their care and spend down that way, it's less work for you. And if you're doing the application, if that's part of your services. All right, I mentioned Medicaid compliant annuity. It's within the Chapter 44 that's referred to the Nebraska Administrative Code. It's under the gifting rules, actually, that describes what an annuity has to be, the qualifications it has to be Medicaid compliant. Has to be actuarially sound, which means that it pays out within your client's life expectancy, not under the IRS tables or anybody else's, but the DHHS federal tables is what we use here. It has to come out in equal payments, so the payments have to be equal for a set number of months, so you can't have one that pays out for life. It has to be a set number of months. Those months have to be within your client's life expectancy under the tables, no matter how unlikely those tables may be. And for most people, those are averages based on people who've been dead for some time now, so they're wrong, right? But that's what we use. There's a payback provision, so if you're doing this and you're using it to maybe give, there's also a planning option where you give the Medicaid compliant annuity not to cover a penalty, but to give an income stream to the spouse whose income is not considered. If the beneficiary passes away, the person receiving those, then any Medicaid benefits paid go an amount equal to, but not to exceed the amount of benefits paid will go to the state. So there's a payback provision written into what makes the Medicaid compliant annuity compliant. If you're using it to get through a penalty period, there won't actually be any Medicaid benefits paid. So so your client wouldn't have received benefits, and there won't be a payback because the benefits are zero. So there's nothing to pay back if you're using it in that mode. So that's there's a lot of numbers, a lot of math to do. Don't try to do it in the console and try to come up with, you ballpark it for folks once you've done a bunch of these, but just say, look, let me work on this, crunch the numbers, and we actually we do charge for that phase of it, because even the work of that and putting together a plan is this substantial work, and you should be compensated for it. I am. So there's a practice pointer. We have 4 minutes left. I haven't had any more questions yet. The state recovery back end of Medicaid issues. States have most, if they participate in Medicaid, which all of them do, they must try to recoup benefits paid from the probate estates of individuals who receive Medicaid benefits, and they may expand estate recovery beyond the probate estate. Last year, Nebraska changed from being what you would call a probate recovery state or a basic estate recovery state, where they just did that minimum of collecting from probate estates. So it was expanded in L.B. 72 was last year's statute. So all those new requirements, there's been a couple seminars on this, of what you have to do with the administration of a revocable living trust, to clear it by DHHS before you can do your final distributions and stay within the law, are a result of that, and it's an attempted estate recovery. Now, as a practitioner who's practiced in this area for a while, I thought LB 72 was a bit odd, because we consistently ran into, as part of the price of admission, we had the DHHS workers were requiring that we empty out revocable living trusts, put them in the client's individual names, maybe because they wanted to be exposed to estate recovery, but that was what they had been doing on the front end. Maybe now that they can recover against revocable, what will be irrevocable on the death, maybe now they'll stop doing that requirement. But I didn't see that provision as a huge change. Just vis-a-vis Medicaid, it's obviously a lot of work in your trust administration practice. So Lawyers Full Employment Act, perhaps. This year there's LB 1103, which started out very, very ambitious. I know if you're a member of the probate, real estate probate and trust section, Ramsey, I just know there's Ramsey, the chair of the section sent out a good summary after the House of Delegates of the NSBA actually voted to oppose the initial version of LB 1103, which seeks to significantly further expand estate recovery in Nebraska. And I raised some concerns. A lot of members, many of you on this conference, I think, are probably among those who had serious concerns about that. There was a significant amendment and scale back of some of the more concerning provisions. I know it's a priority bill for one of the senators, the drafting senator, and it will be still going forward. And I haven't honestly I haven't seen this amendment personally, so I can't tell you much about the specifics of it, but that is something that is worth watching in this area, whether you're going to be doing Medicaid applications or whether you're just in probate administration. This area is something that's going to affect anybody who does probate administration. It's not just notice to the department in your simple probates anymore. It's going to be much more significant. I would also say, I do say in the materials, that these laws, as states expand Medicaid, are often fairly ambitious. Many practitioners in other states have been successful at challenging them. One of the key provisions that I actually quote in the materials is that it has to be something that the person owned at the time of their death in order to be recoverable. And anytime you go into life estates or other kinds of or things that were previously gifted, I think that anything that was subject to that type of treatment is perhaps somewhat questionable in terms of whether it can be recovered. I think I switched you guys over to the written materials. For the purposes, it's the definition of estate that determines what is recoverable. It shall include real property, personal property, other subjects within the individual's estate for state probate law purposes, and may include significant other assets, and that right in the center that, in which the individual had any legal title or interest at the time of death to the extent of such interest. So, certainly states have tried to expand that and go and get as much as they can, which is what they're supposed to be trying to do. But there's been a number of challenges in other states to state programs, and so it is not something that I think should go unexamined over the next couple of years, assuming something significant is passed this year. It should not be something that if you're one of the guys or ladies who has one of those first cases where there's a significant exposure to a state recovery for some reason, it's not something that I would just write the check for. I'd look at it pretty closely, and like I said, there are many other practitioners who've had success in challenging those provisions, and you need to do that, I think, as a due diligence for your clients, frankly, to make sure they're not paying anything over and above what's actually exposed to the estate. And for most folks, it's not going to be much because what was in their estates at the time of their death is going to be nothing. If there's a life estate, if there's joint tenancies, they're going to go after those, and so we'll have to work through what that's going to actually expose. That puts me at 1:03. Get 3 minutes of extra education for all of you. Most of you are still here. I don't see any additional questions in the chat, and so I'll just thank you for listening. You've got the materials, you got the slides, you got my number probably on the first page of the slides, I think. And if you have questions for me or suggestions, thank you very much for participating and for your participation in the bar. If there are any other questions, nothing here, so I go ahead and end the time, I think. Okay? Still being recorded. All right, there everybody going.